This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So the Ninth Circuit has upheld the decision overturning California's ban on large-capacity magazines. It's a very long opinion, but it is extremely well written, so I'm going to try to do the audiobook thing here. We're just going to jump right in because the court really does a great job summarizing everything. Of course, this is probably still going to get challenged, maybe to an en banc panel of the Ninth Circuit, maybe up to the Supreme Court, but as it stands right now, the ban on 10-round or large capacity magazines is overturned, and here's why. This is the Duncan v. Becerra case, so that's Virginia Duncan versus Javier or Xavier Becerra, the Attorney General of the state of California. So this is Circuit Judge Lee writing. In the wake of heart-wrenching and highly publicized mass shootings, the state of California barred its citizens from owning so-called large-capacity magazines that hold more than 10 rounds of ammunition. But even well-intentioned laws must pass constitutional muster. California's near-categorical ban of large-capacity magazines strikes at the core of the Second Amendment, the right to an armed self-defense. Armed self-defense is a fundamental right rooted in tradition and the text of the Second Amendment. Indeed, from pre-colonial times to today's post-modern era, the right to defend hearth and home has remained paramount. California's law imposes a substantial burden on this right to self-defense. The ban makes it criminal for Californians to own magazines that come standard in Glocks, Berettas, and other handguns that are staples of self-defense. Its scope is so sweeping that half of all magazines in America are now unlawful to own in California. Even law-abiding citizens, regardless of their training and track record, must alter or turn over to the state any LCMs that they may have legally owned for years or face up to a year in jail. The state of California has latitude in enacting laws to curb the scourge of gun violence and has done so by imposing waiting periods and many other limitations. But the Second Amendment limits the state's ability to second-guess a citizen's choice of arms if it imposes a substantial burden on her right to self-defense. Many Californians may find solace in the security of a handgun equipped with a large-capacity magazine. Those who live in rural areas where the local sheriff may be miles away, law-abiding citizens trapped in high-crime areas, communities that distrust or depend less on law enforcement, and many more who rely on their firearms to protect themselves and their families. California's almost blanket ban on LCMs goes too far in substantially burdening the people's right to self-defense. We affirm the district court's summary judgment and hold that California Penal Code section 32310, the ban on LCMs, runs afoul of the Second Amendment. In 2016, California amended California Penal Code section 32310 to enact a wholesale ban on the possession of LCMs by almost everyone, everywhere in the state of California. The law says any person in this state who possesses any large-capacity magazine, regardless of the date the magazine was acquired, is a criminal under the law. But the law has not always been so broad. As originally enacted in 2000, it prohibited the manufacture, importation, and sale of LCMs. In other words, California, at first, did not regulate the possession of LCMs. 10 years later, California declared unlawfully possessed LCMs to be a nuisance subject to confiscation and destruction. And in 2013, California further extended the law to prohibit the purchase and receipt of LCMs. It may seem that after the 2013 amendments, California had completed the circle in regulating LCMs. By then, the state had long since foreclosed the transfer and sale of LCMs. As of 2013, it prohibited their purchase and receipt. But the law still allowed Californians who lawfully bought LCMs well before the section's enactment to keep them. So in 2016, the California legislature passed Senate Bill 1446 that prohibited possession of LCMs outright after July 1st, 2017. A few months later, California voters approved Proposition 63, which subsumed that law and strengthened its prohibitions by providing that possession may constitute a misdemeanor offense punishable by up to a year's worth of jail time. The law, as amended, also requires citizens who own LCMs to remove the magazines from the state, sell them to a firearms dealer, or surrender them to law enforcement for destruction. LCM owners may permanently modify non-conforming magazines to accept 10 rounds or fewer, thus removing those magazines from the definition of what constitutes an LCM. Millions of Americans across the country own LCMs. One estimate based in part on government data shows that from 1990 to 2015, civilians possessed about 115 million LCMs out of a total of 230 million magazines in circulation. Put another way, half of all magazines in America hold more than 10 rounds. Today, LCMs may be lawfully possessed in 41 states and under federal law. Notably, LCMs are commonly used in many handguns, which the Supreme Court has recognized as the quintessential self-defense weapon. For example, several variants of the Glock pistol, dubbed America's gun due to its popularity, come standard with a 17-round magazine. Almost all Glock models, except for subcompact variants designed for concealed carry, come standard with magazine capacities greater than 10 rounds. Another popular handgun used for self-defense is the Beretta 92, which entered the market in 1976 and comes standard with a 16-round magazine. Indeed, many popular handguns commonly used for self-defense are typically sold with LCMs. Virginia Duncan and other plaintiffs who lawfully acquired LCMs or represent those who do, collectively we're calling them the owners, brought a constitutional challenge to California Penal Code 32310. 2 days before the possession ban was to take effect, the district court issued a preliminary injunction enjoining enforcement of the law. On appeal, this court affirmed. While the interlocutory, or during litigation, appeal was pending, the owners filed a motion for summary judgment. The district court issued an order granting the owner's motion, concluding that Section 32310 violates the Second Amendment and the Fifth Amendment's takings clause. On the Second Amendment claim, the court rested its extensive decision on 3 independent holdings. First, it concluded that the law did not satisfy the simple Heller test from the Heller case, which queries whether the firearm or firearm component is commonly owned by law-abiding citizens for lawful purposes. Central to the court's analysis were separate reports by 2 expert witnesses, James Curcuruto and Stephen Helsley. The Curcuruto report concluded that there are at least 100 million magazines of a capacity of more than 10 rounds in possession of American citizens, commonly used for various lawful purposes. The Helsley report echoed Curcuruto's findings, noting that after 4 decades of sales, millions of semi-automatic pistols with a magazine capacity of more than 10 rounds, and likely multiple millions of magazines, are in circulation in the United States. The court thus found that millions of ammunition magazines able to hold more than 10 rounds are in common use by law-abiding, responsible citizens for lawful uses like self-defense. Second, the court held that the law fails under strict scrutiny for lack of narrow tailoring. The court found complete prohibition on possession by nearly everyone everywhere to be the hallmark of a sloppy fit. Finally, the district court held that even though it believed intermediate scrutiny was decidedly the wrong standard to apply, that the law still fails under the more lenient intermediate scrutiny standard because the statute was not a reasonable fit to an important public safety interest that it was enacted to serve. As for the Fifth Amendment claim, the court found the law effectuates an unconstitutional taking. Based on these conclusions, the district court found no genuine dispute of material fact that the section violates the Second and Fifth Amendments of the United States Constitution, and ordered summary judgment for the owners. California timely appealed. The state of California argues that the district court erred by granting summary judgment for the owners. We disagree with the government's position and we affirm. The law severely burdens the core of the constitutional right of law-abiding citizens to keep and bear arms. The statute is a poor means to accomplish the state's interest and cannot survive strict scrutiny. But even if we applied intermediate scrutiny, the law would still fail. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. In 2008, the Supreme Court held that the Second Amendment protects an individual right to keep and bear arms in the Heller case. The court later incorporated the Second Amendment to the states through the 14th Amendment's Due Process Clause in McDonald v. City of Chicago. A citizen's right to self-defense, the court held, is deeply rooted in this nation's history and tradition, and fundamental to our scheme of ordered liberty. And indeed, history, text, and tradition underscore that the right to an armed self-defense is fundamental. As the MacDonald decision noted, many legal systems from ancient times to the present day have recognized the right to defend oneself from aggressors. From 1639 to 1660, the British people endured a civil war, and the creation and dissolution of a republic during the interregnum until the Stuart monarchy restoration. Starting in 1662, the Catholic Stuarts persecuted their political enemies, enacting laws that dispossessed all arms from those deemed dangerous to the peace of the kingdom. In 1670, Charles II further restricted possession of guns to the exclusive benefit of the wealthy, the purpose being the prevention of popular insurrections and resistance to the government by disarming the bulk of the people. In the continuing tumult of the Protestant Reformation, James II and VII continued these policies by trying to disarm Protestants while allowing Catholics to maintain arms. Such despotism led to the king's ouster through the Glorious Revolution of 1688 and the enactment of the Declaration of Rights in 1689. Among these true, ancient, and indubitable rights was the right of Protestants to have arms for their defense suitable for their condition, as are allowed by law. And in April of 1775, and closer to home, a ragtag group of private citizens, armed only with their personal firearms and makeshift weapons, fired the shot heard round the world in Concord, Massachusetts. Reminders of British efforts to confiscate personal firearms filled the founders' minds when drafting the Bill of Rights in 1789. During the ratification of the Constitution, anti-federalists raised alarm over a potentially despotic national government that could disarm the people, as occurred under the Stuart kings and other British regimes. In response, the Federalists agreed to include a Bill of Rights, which of course featured the right to bear arms. In sum, self-defense is a basic right recognized by many legal systems from ancient times to the present day, and individual self-defense is the central component of the Second Amendment right. Heller's holding ultimately led the court to invalidate a District of Columbia law that virtually banned all handgun possession in the home and further required all other firearms to be unloaded and disassembled or bound by a trigger lock or similar device. The court found the inherent right to self-defense to be a critical component of the Second Amendment, and that the virtual handgun ban was constitutionally infirm because the handgun is the quintessential self-defense weapon. The court similarly found the disassembly or trigger lock requirements unconstitutional because it makes it impossible for citizens to use arms for the core, lawful purpose of self-defense. But the ruling in Heller was not unlimited and rejected the idea that citizens may keep and carry any weapon whatsoever, in any manner whatsoever, or for whatever purpose. Heller thus recognized that certain exceptions to the Second Amendment apply. For example, weapons that are dangerous and unusual fall outside the Second Amendment's protection. Furthermore, the court cited an open-ended list of presumptively lawful regulatory measures that constitute acceptable long-standing prohibitions on firearm ownership. Such prohibitions include possession of firearms by felons and the mentally ill, prohibitions on carriage in sensitive locations, and conditions or qualifications on the commercial sale of firearms. Applying this court's precedent, we hold that strict scrutiny is the proper standard of constitutional review. California Penal Code Section 32310 cannot withstand this level of scrutiny and is unconstitutional. The Ninth Circuit assesses the constitutionality of firearm regulations under a two-pronged test. This inquiry, 1, asks whether the challenged law burdens conduct protected by the Second Amendment, and 2, if so, directs courts to apply an appropriate level of scrutiny. To determine whether the law burdens protected conduct, this court appears to ask 4 questions. First, as a threshold matter, we determine whether the law regulates arms for the purposes of the Second Amendment. If a regulated arm is both dangerous and unusual, then the regulation does not burden protected conduct, and the inquiry ends. Third, we assess whether the regulation is long-standing and thus presumptively lawful. And fourth, we inquire whether there is any persuasive historical evidence in the record showing that the regulation affects rights that fall outside the scope of the Second Amendment. If either of these latter questions is found in the affirmative, the law does not burden protected conduct and the inquiry ends. If a court finds that a regulation burdens protected conduct, then it must proceed to the second prong of the analysis and determine the appropriate level of scrutiny. This, in turn, requires the court to ask 2 more questions. First, we ask how close the challenged law comes to the core right of law-abiding citizens to defend hearth and home. And second, we analyze whether the law imposes substantial burdens on that core right. If a challenged law does not strike at the core Second Amendment right, or substantially burdens that right, then intermediate scrutiny applies. Only where both questions are answered in the affirmative will strict scrutiny apply. With our course now charted, we apply the first prong of the Ninth Circuit's test to determine whether California Penal Code Section 32310 burdens protected conduct. We hold that it does. Firearm magazines are arms under the Second Amendment. Magazines enjoy Second Amendment protection for a simple reason. Without a magazine, many weapons would be useless, including quintessential self-defense weapons like the handgun. We have opined that where firearms are commonly possessed by law-abiding citizens and for lawful purposes, then there must be some corollary, albeit not unfettered, right to possess the magazines necessary to render those firearms operable. In Jackson, we held that ammunition is a protected arm because, without bullets, the right to bear arms would be meaningless. We are not alone in this assessment. Our colleagues in the Third Circuit expressly held that magazines are protected arms. This was so because magazines feed ammunition into certain guns, and ammunition is necessary for such a gun to function as intended. Put simply, a regulation cannot permissibly ban a protected firearm's components critical to its operation. We next determine whether LCMs are arms that fall outside the scope of the Second Amendment. Heller provides that some arms are so dangerous and unusual that they are not afforded Second Amendment protection. The record before us amply shows that LCMs are commonly owned and typically used for lawful purposes and are not unusual. The Second Amendment guarantees the right to carry weapons typically possessed by law-abiding citizens for lawful purposes. A weapon may not be banned unless it is both dangerous and unusual. In addressing unusualness, the Supreme Court held that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. In other words, just because a weapon was not in existence during the founding era does not mean it is unusual. And where a weapon belongs to a class of arms commonly used for lawful purposes, the relative dangerousness of a weapon is irrelevant. To determine whether an arm is unusual, courts look to an arm's commonality and whether it is typically possessed by law-abiding citizens for purposes of self-defense. Commonality is determined largely by statistics, but a pure statistical inquiry may hide as much as it reveals. In the Second Amendment context, protected arms may not be numerically common by virtue of an unchallenged unconstitutional regulation. Our colleagues in the Third and Seventh Circuits agree. Thus, while common use is an objective and largely statistical inquiry, typical possession requires us to look into both broad patterns of use and the subjective motives of gun owners. As discussed earlier, nearly half of all magazines in the US today hold more than 10 rounds of ammunition, and the record shows that such magazines are overwhelmingly owned and used for lawful purposes. This is the antithesis of unusual. Gesundheit. That LCMs are commonly used today for lawful purposes ends the inquiry into unusualness, but the record before us goes beyond what is necessary under Heller. Firearms or magazines holding more than 10 rounds have been in existence and owned by American citizens for centuries. Firearms with greater than 10-round capacities even existed before our nation's founding, and the common use of LCMs for self-defense is apparent in our shared national history. Semi-automatic and multi-shot firearms were not novel or unforeseen inventions to the founders, as the first firearm that could fire more than 10 rounds without reloading was invented around 1580. Rapid-fire guns, like the famous Puckle gun, were patented as early as 1718 in London. Moreover, British soldiers were issued magazine-fed repeaters as early as 1658. As a predecessor to modern revolvers, the pepperbox pistol design predates the American Revolution by nearly 100 years, with common variants carrying 5 to 7 shots at the ready, and with several European variants able to shoot 18 or 24 shots before reloading individual cylinders. Similarly, breech-loading repeating rifles were conceptualized as early as 1791. After the American Revolution, the record shows that new firearm designs proliferated throughout the states and few restrictions were enacted on firing capacities. The Girandoni air rifle, developed in 1779, had a 22-round capacity and was famously carried on the Lewis and Clark expedition. In 1821, the Jennings multi-shot flintlock rifle could fire 12 shots without reloading. Around the late antebellum period, one variant of the Belgian Mariette repeating pepperbox could fire 18 shots without reloading. Pepperbox pistols maintained popularity over smaller capacity revolvers for decades, despite the latter being of newer vintage. At this time, revolving rifles were also developed, like the Hall rifle that held 15 shots. The advent of repeating cartridge-fed firearms occurred at the earliest, in 1855 with the Volcanic Arms lever-action rifle that contained a 30-round tubular magazine, and at the latest in 1867 when Winchester created its Model 66, which was a full-size lever-action rifle capable of carrying 17 rounds. The carbine variant was able to hold 12 rounds. Repeating rifles could fire 18 rounds in half as many seconds, and over 170,000 were sold domestically. The Model 66 Winchester was succeeded by the Model 73 and Model 92, combined selling over 1.7 million total copies between 1873 and 1941. You wouldn't download a gun. The innovation of the self-contained cartridge, along with stronger steel alloys, also fostered development in handguns, making them smaller and increasing their capacities. Various revolver designs from France and Germany enabled up to 20 shots to be fired without reloading. A chain-fed variant, the French Goicot, allowed pistols to carry up to 32 shots and a rifle up to 100 shots. One American manufacturer experimented with a horizontally sliding row of chambers, an early stacked magazine, through a common frame, dubbed the Jarrah Harmonica pistol, holding 10 rounds and patented in 1862. In 1896, Mauser developed what might be the first semi-automatic recoil-operated pistol, the broom handle, with a detachable 20-round magazine. Luger's semi-automatic pistol hit the market in 1899 and came with 7 or 8 round magazines, although a 32-round drum magazine was widely available. In 1935, Browning developed a 13-round high-power pistol, which quickly achieved mass-market success. Since then, new semi-automatic pistol designs have replaced the revolver as the common, quintessential self-defense weapon. Many of these pistol models have increased magazine capacities as a result of double-stacked magazines. One of the most popular handguns in America today is the Glock 17, which comes standard, with a magazine able to hold 17 bullets. Rifle magazine development paralleled that of pistol magazines. In 1927, Auto Ordnance Company released its semi-automatic rifle with a 30-round magazine. A decade and a half later, the M1 carbine was invented for the citizen soldier of World War II. The M1 remained a common and popular rifle for civilians after the war. In 1963, almost 250,000 M1s, capable of holding between 15 and 30 rounds, were sold at steeply discounted prices to law-abiding citizens by the federal government. The ultimate successor to the M1 was the M16, with a civilian version dubbed the Armalite Model 15 or AR-15. The AR-15 entered the civilian market in 1963 with a standard 20-round magazine and remains today the most popular rifle in American history. The AR-15 was central to a 1994 Supreme Court case in which the court noted the semi-automatic rifle, capable of firing only one shot with each pull of the trigger, traditionally have been widely accepted as lawful possessions. By the early 1970s, the AR-15 had competition from other American rifle models, each sold with manufacturer standard 20-round or greater magazines. By 1980, comparable European models with similar capacities entered the American market. The point of our long march through the history of firearms is this. The record shows that firearms capable of holding more than 10 rounds of ammunition have been available in the United States for well over 2 centuries. While the Supreme Court has ruled that arms need not have been common during the founding era to receive protection under the Second Amendment, the historical prevalence of firearms capable of holding more than 10 bullets underscores the heritage of LCMs in our country's history. Thus, we hold that LCMs are not unusual arms, and because LCMs are not unusual, we need not opine on their dangerousness under the court's test. Dangerousness is a more difficult decision because weapons are necessarily dangerous. The very attributes that make handguns particularly useful for self-defense are also what makes them particularly dangerous. While we do not opine on the dangerousness of LCMs, we note that statistics in the record show that criminal use of LCMs is relatively low compared to their market saturation. Despite nearly 115 million LCMs in circulation in America today, between 1982 and 2012, LCMs were used 31 times in an incident where 4 or more people were killed. Let us be perfectly clear. We do not cite these statistics to downplay the gravity of these tragic and heartbreaking events. Rather, they are necessary to discern the broad patterns of use and subjective motives of gun owners when assessing whether typical possession is for lawful purposes. Based on the statistics in the record, we conclude that LCMs are in fact both commonly owned and typically possessed for lawful purposes. The state claims that LCMs fall outside the scope of the Second Amendment because they are most useful in military service. But that claim misses the mark. The state relies on a Fourth Circuit case in which a sharply divided court held that LCMs are not arms protected by the Second Amendment because they are most useful in military service. That case, Colby, remains an outlier, and other circuits have rejected its analysis. We reaffirm the test announced by the Supreme Court in the Heller case and Caetano. Arms are not unusual if commonly owned and typically used by law-abiding citizens for lawful purposes. Some firearm prohibitions are presumptively lawful because of their long-standing nature. Heller lists 3 types of permissible regulations that are presumptively consistent with the Second Amendment. Prohibitions on possession by the mentally ill or felons, laws forbidding carriage in sensitive places, and laws that place qualifications on commercial sales of firearms. But because this list was held to be non-exhaustive by Heller and later affirmed in McDonald, a court reviewing other types of laws must determine whether those laws are sufficiently long-standing regulations. This, of course, raises the question of what constitutes a sufficiently long-standing regulation. In our circuit, we have looked for evidence showing whether the challenged law traces its lineage to Founding Era or Reconstruction Era regulations. In Chauvin, for example, we expressed strong doubts that bans on firearm possession for violent offenders were sufficiently long-standing because the first known restriction was not enacted until 1938. In Jackson, we reviewed regulations on handgun storage and sales of certain ammunition, keying our analysis to analogs in Founding Era and Reconstruction Era fire safety laws. The California law cannot be considered a long-standing regulation that enjoys presumptive legality. As noted above, when the founders ratified the Second Amendment, no laws restricted ammunition capacity despite multi-shot firearms having been in existence for some 200 years. Only during Prohibition did a handful of state legislatures enact capacity restrictions. As the Third Circuit in the ANJRPC case noted, LCMs were not regulated until the 1920s, but most of those laws were invalidated by the 1970s. At the federal level, Congress chose to impose the strictest regulations on fully automatic machine guns, with the National Firearms Act of 1934. But despite its strong regulations, the law imposed no similar restrictions on magazine possession. Congress briefly prohibited LCMs with capacities greater than 10 rounds when it enacted the Violent Crime Control Law of 1994. But even during the 10 years between the federal ban's enactment and expiration, a grandfather clause allowed continued possession for previously purchased LCMs. In fact, the only statute regulating LCMs that has been in continuous existence, and only since 1932, is found in the District of Columbia, which prohibits possession of a firearm that shoots automatically or semi-automatically more than 12 shots without reloading. Only recently, and in apparent conjunction with the 1994 federal experiment banning assault weapons, have a small smattering of states experimented with various LCM regulations. In sum, laws restricting ammunition capacity emerged in 1927 and all but one have since been repealed. Modern LCM restrictions are of an even younger vintage, only enacted within the last 3 decades. Thus, the LCM restrictions of California Section 32310 cannot be considered long-standing and thus do not enjoy a presumption of lawfulness. In a similar vein, courts may assess historical understandings to determine whether a challenged law is a permissible regulation. To do so, we must look for persuasive historical evidence establishing that the regulation at issue imposes prohibitions that fall outside the historical scope of the Second Amendment. The record before us provides no persuasive historical evidence showing that LCM possession is understood to fall outside the scope of the Second Amendment. As discussed above, the historical record shows that LCM restrictions are modern creations. The Seventh Circuit, in Ezell v. City of Chicago, reached a similar conclusion. That case involved a municipal ordinance that required firing range training as a prerequisite to gun ownership while prohibiting all firing ranges in the city of Chicago. That's big brain stuff right there. The Ezell court was presented with two laws from 1826 and 1831 that were relevant to its analysis. These laws fell far short of establishing that target practice is wholly outside the Second Amendment, as it was understood when incorporated in a limitation on the states. As for prong one of our analysis, the record shows that LCMs are not subject to the exceptions announced in Heller. Magazines are protected arms, and large-capacity magazines are not unusual. LCMs have never been subject to long-standing prohibitions, and a historic analysis fails to persuade that LCMs otherwise fall outside constitutional protections. We hold that California Penal Code Section 32310 burdens protected conduct and proceed to the second prong of the analysis. Because the section burdens protected conduct, we must now determine what standard of constitutional scrutiny applies. The law strikes at the core right of law-abiding citizens to defend hearth and home, and the burden imposed on that core right is substantial. As this court has held, where a burden on the core right is substantial, strict scrutiny is appropriate. Heller held that the core Second Amendment right is for law-abiding citizens to defend hearth and home. This is a simple inquiry. If a law regulating arms adversely affects a law-abiding citizen's right of defense of hearth and home, Section 32310 strikes at the core of Second Amendment rights. By banning LCMs everywhere for nearly everyone, it necessarily bans possession of LCMs within the home, where protections are at their zenith. We stated in the Fayok case that because Sunnyvale's LCM ordinance restricts the ability of law-abiding citizens to possess large-capacity magazines within their homes for the purpose of self-defense, the ordinance may implicate the core of the Second Amendment. The Second Amendment in NYSRPA was a bit more explicit. The court held there that LCM restrictions by their terms implicate the core of the Second Amendment's protection by extending into the home, where the need for defense of self, family, and property is most acute. So, too, here. The California law burdens core Second Amendment rights in a substantial way, requiring us to review it under strict scrutiny. The law categorically bars the possession of magazines that are commonly used in handguns, the quintessential self-defense weapon. And it bans LCM possession for nearly everyone, everywhere in California. Simply put, any law that comes close to categorically banning the possession of arms that are commonly used for self-defense imposes a substantial burden on the Second Amendment. While the political branches enjoy latitude to craft legislation to stamp out gun violence, their powers are not limitless if they encroach on an enumerated right enshrined in our Constitution. Moreover, the Second Amendment is more than just a right guaranteed in our Bill of Rights. As the Supreme Court has held, self-defense is a fundamental individual right that is necessary to our system of ordered liberty. It is also pre-existing. This is not a right granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. In short, the right of armed self-defense sits atop our constitutional order and remains rooted in our country's history. Any law that limits this right of self-defense must be evaluated under this constitutional and historical backdrop. The seeds of the modern right to defend oneself germinated from fertile ground long ago. The English Bill of Rights, considered the predecessor to our own, conferred an individual right to self-defense. Quote, "The right secured in 1689 as a result of the Stuarts' abuses was, by the time of the founding, understood to be an individual right, protecting against both public and private violence. And by the time of the founding, the right to have arms had become fundamental for English subjects. American colonists similarly understood their rights to include the right of self-preservation as permitting a citizen to repel force by force when the intervention of society in his behalf may be too late to prevent an injury. This belief was galvanized by George III's attempt to disarm the colonists just as the Stuarts attempted to disarm the Protestants. Before our federal Bill of Rights was ratified, at least 4 states, Pennsylvania, Vermont, North Carolina, and Massachusetts, included within their state constitutions or Declaration of Rights a guarantee to keep and bear arms. Shortly after the ratification of our Constitution, at least 9 states' constitutions enshrined a right of citizens to bear arms in defense of themselves and the state, or bear arms in defense of himself and the state. Perhaps the most poignant and persuasive reminder of the fundamental right to self-defense rests in the denial of that right to Black Americans during the tragic chapters of our country's history. After the founding, Southern states often severely limited or outright prohibited firearm possession by slaves, freedmen, and others. The judicial branch, too, played a role in denying this fundamental right of self-defense to blacks. In the infamous Dred Scott v. Sanford decision, Chief Justice Taney recited a parade of horribles if Black Americans were to be considered citizens. It would give blacks the right to enter every other state whenever they pleased, to exercise full liberty of speech, to hold public meetings upon political affairs, and to keep and carry arms whenever they want. It did not get much better even after a bloody civil war that tore the country apart. Post-Civil War state legislation and the black codes in the South deprived newly freed slaves of their Second Amendment rights. Meanwhile, armed bands of ex-Confederates roamed the countryside, forcibly disarming and terrorizing African Americans. The radical Republicans in Congress fought back against these systematic efforts to disarm Black Americans by enacting the Freedmen's Bureau Act of 1866 and the Civil Rights Acts of 1866. Both of which guaranteed all persons the right of self-defense. But laws promising protection and equality for African Americans rang hollow because in the post-Reconstruction era, the Ku Klux Klan and other marauding bands of terrorists slaughtered thousands of unarmed Black Americans. Not surprisingly, Black Americans embraced their right to self-defense, understanding that protections offered by the state may be promising in theory, but fatal in fact. Ida B. Wells, the crusading journalist who co-founded the NAACP, wrote that a Winchester rifle should have a place of honor in every black home, and it should be used for that protection which the law refuses to give. Martin Luther King Jr., despite his nonviolent approach to protest, owned numerous firearms and hired armed men to guard his house during the Montgomery bus boycott in 1956. One civil rights activist who visited Dr. King's home during that time described the house as an arsenal. Stories of other civil rights activists exercising their right to self-defense are legion. While the NAACP espoused nonviolence, many of its members carried firearms for self-protection, and for good reason. Aaron Henry, then a branch president of the NAACP, would openly display his firearm after his house was firebombed in 1963. When NAACP activist Hartman Turnbow tried to register to vote, night riders lit his house on fire with Molotov cocktails. Turnbow recounted that he grabbed his rifle, escaped the burning building, and exchanged gunfire with 2 white men waiting outside. The men fled once Turnbow started shooting back. Wells documented that, of the many inhuman outrages of that year, the only case where the proposed lynching did not occur was where the men armed themselves and prevented it. The only times an Afro-American who was assaulted and got away has been when he had a gun and used it in self-defense. During the crucible of the civil rights movement, Black American veterans from World War II and the Korean War founded the Deacons for Defense and Justice to protect black people from racial violence at the hands of the Ku Klux Klan. In 1966, the small Louisiana town of Bogalusa integrated the local junior high school to the ire of the local Klan. Armed with guns, this roving band of racist terrorists arrived at the junior high school. Their intentions were obvious. In that small town, 2 African Americans, one of whom was a deputy sheriff, had recently been killed by white people. But this time around, the Klan encountered something unexpected at the entrance of the school. The Deacons for Defense and Justice, armed with revolvers and rifles, and rooted in righteousness and resolution. Outgunned by the Deacons, the Klan fled. As one member of the Deacons noted afterwards, from that day forward, we didn't have too many more problems. These terrible events did not occur long ago in faraway lands. They occurred on American soil, some less than 60 years ago, and tragically, they are not unique. Indeed, Black Americans' existence throughout the civil rights movement was just the latest iteration in an ongoing struggle to defend hearth and home from those who wished them ill. This was part of a long-standing tradition of revolts, armed resistance, and self-defense that developed during slavery and continued after emancipation when Reconstruction failed to deliver political and social equality for Black Americans. Our country's history has shown that communities of color have a particularly compelling interest in exercising their Second Amendment rights. The Second Amendment provides one last line of defense for people of color when the state cannot or will not step in to protect them. This remains true today across all communities of color. For example, amid the COVID-19 pandemic, Asian Americans have become the target of physical attacks by those who scapegoat them for the virus. In response to those assaults and threats to their lives, Asian Americans have begun arming themselves. When one Asian mother was asked why she was buying a pistol, she replied in tears, "To protect my daughter." Another Asian immigrant purchasing an AR-15 rifle feared violence should COVID-19 deaths continue to mount. Quote, "And when all these bad things come, I am a minority. People can see my face is Chinese clearly. My son, when he goes out, they will know his parents are Chinese." People of color are not alone in relying on the Second Amendment to protect themselves when the state's protections fail them. We need look no further than the facts in the Supreme Court's Caetano decision. Jaime Caetano obtained multiple restraining orders against her abusive boyfriend after he put her in the hospital. Unfortunately, restraining orders meant little to her abuser. He continued to stalk and menace her. One day, he waited for her outside her workplace, but this time she came armed. The abusive boyfriend got scared and left her alone. Her story is not unique. For many women, a firearm may be the equalizer against their abusers and assailants when the state fails to protect them. So too, for members of the lesbian, gay, bisexual, and transgender communities. They are disproportionately the victim of hate crimes and other types of criminal violence because they are perceived as safe targets for violence and hateful acts. As Amici Pink Pistols explained in their brief, armed self-defense can dispel those perceptions and deter such attacks against LGBT members. We mention these examples to drive home the point that the Second Amendment is not a second-class right, nor is self-defense a dispensation granted at the state's mercy. Rather, the Second Amendment is a fundamental constitutional right guaranteed to the people, especially those who may not be equally protected by the state. Moreover, the Second Amendment is not a relic relevant only during the era of Publius and parchments. It is a right that is exercised hundreds of times on any given day. The parties and amici disagree on the number of times that guns are used for defensive purposes, offering anywhere from 240,000 to 2.5 million times per year. That means an average of 657 Americans, and perhaps up to almost 7,000 Americans, use guns to defend themselves every single day of the year. We take notice of this fact in recognizing the fundamental right of self-defense. California Penal Code Section 32310 substantially burdens core Second Amendment rights because of its sweeping scope and breathtaking breadth. Half of all magazines in the US are now illegal to own in California. It does not matter that these magazines are not unusual and are used commonly in guns for self-defense. Law-abiding citizens must alter or turn them over, or else the government may forcibly confiscate them from their homes and imprison the persons for up to a year. The law's prohibitions apply everywhere in the state and to practically everyone. It offers no meaningful exceptions at all for law-abiding citizens. These features are the hallmark of a substantial burden. The state argues that its law does not impose a substantial burden on the Second Amendment because citizens can still defend themselves with guns equipped with non-LCMs. But the Supreme Court in Heller rejected that type of policy argument when it comes to a fundamental constitutional right. We know from that case that a regulation may impose a substantial burden on the Second Amendment even though the restriction does not foreclose the right to self-defense. The District of Columbia law banning possession of handguns did not prevent citizens from defending themselves because, as the district argued, they could still use a shotgun or a variety of other arms to defend themselves. But the Supreme Court rejected the argument that it is permissible to ban the possession of handguns so long as the possession of other firearms is allowed. Because the law banned an entire class of arms that is overwhelmingly chosen by American society for self-defense, a handgun in that case, the restriction was severe and ran afoul of the Second Amendment. California's law, too, bans an entire class of arms that is commonly used for self-defense and thus infringes on the Second Amendment. The state essentially invites us to engage in a policy decision that weighs the pros and cons of an LCM ban to determine substantial burden. That is exactly what the dissent in Heller proposed. Ask whether the statute burdens a protected interest in a way or to an extent that is out of proportion to the state's salutary effects upon other important governmental interests. That was Justice Breyer. But the Supreme Court in Heller took any such policy balancing notion off the table. Quote, "The very enumeration of the right takes out of the hands of government, even the third branch of government, the power to decide on a case-by-case basis whether the right is really worth insisting upon. A constitutional guarantee subject to future judges' assessments of its usefulness is no constitutional guarantee at all. Constitutional rights are enshrined with the scope that they were understood to have when the people adopted them, whether or not future legislatures, or yes, even future judges, think that scope too broad." Put another way, a substantial burden on the Second Amendment is viewed not through a policy prism, but through a lens of a fundamental and enumerated constitutional right. We would be looking through the wrong end of a sight glass if we asked whether the government permits the people to retain some of the core fundamental and enumerated rights. Instead, Heller counsels us to look at whether the government regulation restricts the core fundamental right from the outset. In other words, we look to what a restriction takes away rather than what it leaves behind. Here, California's law takes away a substantial swath of the core constitutional right of self-defense because it bans possession of half of all magazines in America today, even though they are common in guns and used for self-defense. In short, a law that takes away a substantial portion of arms commonly used by citizens for self-defense imposes a substantial burden on the Second Amendment. Notably, the Supreme Court has taken a similar approach in a kaleidoscope of cases involving other fundamental enumerated rights. The court does not look away from a governmental restriction on the people's liberty just because the state did not impose a full-tilt limitation on a fundamental and enumerated right. Rather, in assessing a governmental imposition on a fundamental right, the court shuns policy balancing and focuses on the erosion of the people's liberties. We find ourselves in good company in declining the state's invitation to hold otherwise. Our decision today is in keeping with Ninth Circuit precedent. While we have not articulated a precise standard for what constitutes a substantial burden on core Second Amendment rights, we have consistently stated that a law that bans possession of a commonly used arm for self-defense, with no meaningful exception for law-abiding citizen, likely imposes a substantial burden on the Second Amendment. And for good reason. The Supreme Court has scrutinized with a gimlet eye on any limitation of a fundamental right exercised at home because such an imposition by its nature severely restricts individual liberty. Here, the state effectively intrudes into the homes of law-abiding citizens to forcibly confiscate arms that they rely on for self-defense. If the Supreme Court has made one thing clear time and again, it is that the home is a sanctuary and the government should be chary to intrude. So, in Jackson, we held that a bar on the sale of hollow point ammunition within city limits was not a severe burden because San Francisco residents could still own that ammunition within the home. We thus applied intermediate scrutiny to the regulation. Stated differently, we implied that strict scrutiny likely applies if a law completely bans the possession of a certain class of ammunition, their hollow point bullets. 2 years later, in Sylvester, we applied intermediate scrutiny to a 10-day waiting period because it did not completely ban possession. We held that such regulations were more akin to time, place, or manner restrictions in the First Amendment context. In doing so, we implied that a complete ban on possession likely merits a more stringent review than intermediate scrutiny. Then, in 2018, in Pena, the court reaffirmed that possession bans on arms are strong medicine, likely requiring strict scrutiny. We held that a grandfather provision was important to our decision to apply intermediate scrutiny. Put differently, the lack of a grandfather provision likely requires strict scrutiny because governmental bans on possession cut deeply into core constitutional rights to protect hearth and home. Perhaps this point was made most clear in the Chauvin case. While we applied intermediate scrutiny on a ban of arms for domestic violence misdemeanors, we made clear that the standard was different for law-abiding citizens. If a ban on arms borders on a total prohibition of ownership for law-abiding citizens, the burden is substantial. Turning to whether Section 32.310 imposes a substantial burden on the Second Amendment, the record makes that answer plainly obvious. Half of all magazines in America are prohibited under California's law. The state threatens imprisonment if law-abiding citizens do not alter or turn them over. It does not matter that LCMs come standard for guns commonly used for self-defense, or that law-abiding citizens may have owned them lawfully for years or even decades. When the government bans tens of millions of protected arms that are staples of self-defense and threatens to confiscate them from the homes of law-abiding citizens, that imposes a substantial burden on core Second Amendment rights. Moreover, California's law has no meaningful exceptions for law-abiding citizens. There is no grandfather clause that Pena found important to avoid strict scrutiny. None of the limited exceptions in the statute speak to the average law-abiding citizen, and none mitigate the severe burdens imposed by the law on core Second Amendment rights. California's LCM ban applies to almost everyone, everywhere, and to nearly every weapon that can reasonably be expected to be used for self-defense. If a far-reaching law restricts arms containing no meaningful exceptions for law-abiding citizens who use them for self-defense, it invites strict scrutiny. The law also cannot be considered merely a time, place, or manner regulation. Unlike Jackson's storage requirements, a wholesale statewide prohibition on possession of 1 out of every 2 magazines is greater in scope and severity. And Pena's micro-stamping requirement for guns could properly be considered a manner restriction because it did not dispossess owners of non-conforming weapons. The same can be said for the law in Sylvester that otherwise did not affect how a citizen exercises her Second Amendment rights after completing the 10-day waiting period. California's law instead appears to be more like the firing range restrictions that the Seventh Circuit in Ezell struck down. The city of Chicago had banned shooting ranges within city limits, which the Seventh Circuit held was a serious encroachment to the right of self-defense. This, the court held, constituted more than a restriction on the manner in which those rights were exercised because of the importance of having weapons training and proficiency among the firearm-owning public. The magazine restrictions here, as in Ezell, amount to a serious encroachment. More fundamentally, no court would ever countenance similar restrictions for other fundamental rights. The nub of the state's position is that even though it bars Californians from owning 1 of every 2 magazines in the US, that restriction is not substantially burdensome because Californians can still possess other magazines. But no court would hold that the First Amendment allows the government to ban extreme artwork from Mapplethorpe just because the people can still enjoy Monet or Matisse. No court would ever allow the government to outlaw so-called dangerous music by Dr. Dre merely because the state has chosen not to outlaw Debussy. And we would never sanction governmental banning of allegedly inflammatory views expressed in the Daily Kos or Breitbart on the grounds that the people can still read the New York Times or the Wall Street Journal. The state relies on the fallback position that the Second Amendment deserves less protection because it allegedly poses an inherent danger to public safety that the other rights do not. But individual rights often impose at least some risk on public safety. The right to keep and bear arms is not the only constitutional right that has controversial public safety implications. All of the constitutional provisions that impose restrictions on law enforcement and on the prosecution of crimes fall into the same category. The exclusionary rule in criminal procedure is a clear example. Under that doctrine, the criminal is to go free because the constable has blundered. Surely, too, the government's efforts to secure damning criminal confessions has been hobbled since Miranda v. Arizona. The most basic function of any government is to provide for the security of the individual and of his property. The rule announced today will measurably weaken the ability of the criminal law to perform those tasks, says the court in 1966 in Miranda, Justice White dissenting. This is not hypothetical. Criminals sometimes go free because our society prioritizes individual constitutional rights over concerns that freed offenders may commit crimes again. There is also no stopping point to the state's argument. Under its logic, California could limit magazines to as few as 3 bullets and not substantially burden Second Amendment rights because, on average, 2.2 bullets are used in every defensive encounter according to a study. But the threat to life does not occur in an average act in the abstract. Self-defense takes place in messy, unpredictable, and extreme events. And what's more, the state's logic is in no way limited to restricting the number of bullets in a magazine. If it is not substantially burdensome to limit magazines to 10 rounds because the average defensive shooter uses fewer bullets, then there is no reason it could not impose a 1 gun per person rule. In fact, there is a more compelling case to impose a 1 gun policy under the state's theory. After all, the study relied on by the state also shows that an overwhelming majority of mass shootings involved the use of multiple guns, while a relative few definitively involved LCMs. This cannot be right. We would never uphold such a draconian limitation on other fundamental and enumerated constitutional rights. More broadly, the government's argument misses the mark because the Second Amendment limits the state's ability to second-guess the people's choice of arms if it imposes a substantial burden on the right to self-defense. As discussed above, substantial burden cannot be a policy-balancing inquiry because it implicates a fundamental constitutional right. Banning the ownership of half the magazines in America inflicts a substantial burden on the Second Amendment. In any event, it does not take a wild imagination to conclude that citizens may need LCMs to defend hearth and home. While Hollywood and the Bay Area symbolize California to the world, the Golden State is in fact a much more diverse and vibrant place with people living in sparsely populated rural counties, seemingly deserted desert towns, and majestic mountain villages. In such places, the closest law enforcement may be far, far away, and it may take substantial time for the county sheriff to respond. And it is no guarantee that the things that go bump in the night come alone. Indeed, burglars often ply their trade in groups, recognizing strength in numbers. Law-abiding citizens in these places may find security in a gun that comes standard with an LCM. Further, some people, especially in communities of color, do not trust law enforcement and are less likely, over 40% less likely according to one study, to call 911 even during an emergency. These citizens may rely more on self-defense than the average person in a home invasion or some other emergency. I personally have a major concern with calling 911 in the States because half the time the police respond, they've already got some idea of what they think happened without even talking to the parties, and they're already acting against someone's best interests, or the best interests of the situation. The big one that I keep hearing is when someone calls police to respond to a mental health situation, the police end up shooting and killing the mentally ill person who really just needed a mental health intervention as opposed to a violent intervention. Law-abiding citizens trapped in high-crime areas where law enforcement is overtaxed may defend themselves in their homes with a handgun outfitted with LCMs, and in incidents of mass chaos and unrest, law enforcement simply may be unable to protect people, leaving them solely responsible for their own safety in a seemingly Hobbesian world. Finally, many citizens will not take any chances or compromise their ability to defend themselves and their families, and they may place their trust in guns equipped with LCMs as a last resort. Simply put, the guardrails found in our precedent that limit the government's intrusion on the Second Amendment right do not exist in California's near categorical ban of LCMs. It imposes a substantial burden on people's Second Amendment rights. Strict scrutiny applies. The state attempts to seek refuge in the holdings of extra circuit authority, so other decisions outside of this court's precedent. We call that persuasive precedent. But those decisions present myriad distinctions and are inopposite. To begin, many of the other states' laws are not as sweeping as California's. Maryland's state law did not ban possession of LCMs, but only barred the sale of them. Massachusetts has a state law with a grandfather clause that allows people to keep their LCMs if they already own them. As our court has explained, laws that only ban the sale of arms or include a grandfather clause impose a lesser burden. Moreover, almost all of the other states' laws banned both LCMs and assault weapons. As a result, the decisions too often conflated the analysis between the two. For example, the D.C. Circuit in Heller v. District of Columbia Heller 2 upheld the ban on assault weapons and LCMs because the record reflected that assault weapons are not typically used for self-defense, quoting a study that revolvers and semi-automatic pistols are together used almost 80% of the time in incidents of self-defense with a gun. But semi-automatic pistols used for self-defense, such as a Glock, routinely use LCMs, and in fact, an LCM is the standard magazine that comes equipped with the gun. The analysis in many of these cases is thus rendered unsound for our purposes today, as we only opine on the validity of California's LCM ban. The state relies on the court's decision in Fyock v. City of Sunnyvale to maintain that intermediate scrutiny should apply here, but it hangs too heavy a hat on too small a hook. Fyock does not hold that, as a matter of law, intermediate scrutiny applies to LCM regulations. In Fyock, we did not reach the merits of the case, but instead were asked to review a preliminary injunction denial relating to an LCM ban in the City of Sunnyvale, based on a limited record. Critically, we acknowledge that we were merely considering whether the district court abused its discretion in applying intermediate scrutiny. So, abuse of discretion and intermediate scrutiny, different standards. We held only that the district court did not abuse its discretion by choosing intermediate scrutiny based on the limited record before it on a preliminary injunction appeal. The abuse of discretion standard, of course, is highly deferential, and an appellate court can reverse only if the trial court made a clear error of judgment. The limited nature of that opinion is self-evident. In its 8 pages, it referenced the abuse of discretion standard 12 times, and it repeatedly emphasized the narrow scope of the ruling. It is perhaps understandable why our court in Fyock ruled as it did in light of the deferential standard of review and the unique facts presented in that case. Sunnyvale is a small and affluent community. Compare the City of Sunnyvale's crime report, 1.7 incidents per 1,000 people, with the California Department of Justice report for California, 4.4 incidents per 1,000 people. And Sunnyvale boasts one of the largest combined public safety departments in the United States. Simply speaking, we are not in Sunnyvale anymore. California Penal Code Section 32310 substantially burdens core Second Amendment rights. It bans LCMs that come standard in guns commonly used for self-defense in the home. Its scope is broad and indiscriminate, and it provides no meaningful exceptions for law-abiding citizens. Strict scrutiny applies under the reasoning of our prior decisions, a law that implicates the core of the Second Amendment right and severely burdens that right warrants strict scrutiny. Apart from this circuit's two-prong analysis for tiers of scrutiny, our approach is in keeping with how we generally address fundamental rights in our Constitution. As the Supreme Court held, the Second Amendment is a fundamental right that is necessary to our system of ordered liberty. When the government tries to limit the people's fundamental rights, the Supreme Court typically presumes that strict scrutiny applies. And it makes sense to do so. If the government imposes a substantial limitation on our most sacred and fundamental rights enumerated in our Constitution, then such a law restricting the people's liberty should face the highest tier of scrutiny. Strict scrutiny is the most rigorous and exacting standard of constitutional review and requires that a state law be narrowly tailored to achieve a compelling interest. If there are other reasonable ways to achieve a compelling state purpose with a lesser burden on constitutionally protected activity, a state may not choose the way of greater interference. If it acts at all, it must choose less drastic means. In the court below, the state advanced 4 interests underlying the California law: protecting citizens from gun violence, protecting law enforcement from gun violence, protecting public safety, and preventing crime. The district court found these interests to be important. On appeal, the Attorney General does not explicitly enumerate these 4 interests, but does stylize them as interests in preventing and mitigating gun violence, particularly public mass shootings and the murder of law enforcement personnel. The state claims that these interests are compelling. We agree. California Penal Code Section 32310 cannot withstand strict scrutiny analysis because the state's chosen method, a statewide blanket ban on possession everywhere and for nearly everyone, is not the least restrictive means of achieving the compelling interest. As discussed above, Section 32310 provides few meaningful exceptions for the class of persons whose fundamental rights to self-defense are burdened. The scope of Section 32310 likely dooms its validity. It applies statewide. It necessarily covers areas from the most affluent to the least. It prohibits possession by citizens who may be in the greatest need of self-defense, like those in rural areas or places with high crime rates and limited police resources. It applies to nearly everyone. It is indiscriminating in its prohibition, nor is the law limited to firearms that are not commonly used for self-defense. These are not features of a statute upheld by courts under the least restrictive means standard. As made plain by our earlier decision, intermediate scrutiny is the wrong standard to apply, but even if we were to apply it today, California Penal Code Section 32310 would still fail. While that provision doubtless purports to serve important state interests, the means chosen by the state are not substantially related to serving those interests. Courts apply intermediate scrutiny in a variety of contexts. Broadly speaking, to survive intermediate scrutiny, a statute must be substantially related to an important government objective. Recently, the Supreme Court emphasized the potent nature of intermediate scrutiny. In Packingham v. North Carolina, the court held that to survive intermediate scrutiny, a law must be narrowly tailored to serve a significant government interest. While the precise contours of intermediate scrutiny may vary, this much is certain: it has bite. It is a demanding test. While its application is neither fatal nor feeble, it still requires the reviewing court to scrutinize a challenged law with a healthy dose of skepticism. Indeed, the law must address harms that are real in a material way. At its core, intermediate scrutiny is a searching inquiry. This circuit has used seemingly varying formulas of intermediate scrutiny in the Second Amendment context. Chauvin provides that intermediate scrutiny requires 1. The government's stated objective be significant, substantial, or important, and 2. A reasonable fit between the challenged regulation and the asserted objective. But in Sylvester, we stated that gun regulations need only provide a substantial government interest that would be achieved less effectively absent the regulation. We cited both standards in Pena, though that decision appears to interpret the latter as a means to assess the fit prong of the former. Other decisions within our court and elsewhere have used language that suggests varying intensities of bite. Some applications of intermediate scrutiny are severe, others are less stringent, and a few fall somewhere in between. Whatever its precise contours may be, intermediate scrutiny cannot approximate the deference of rational basis review. Heller forecloses any such notion. Yet the state asserts that the deferential standard presented by the case of Turner Broadcasting applies here, but reliance on this line of cases is misplaced. While some courts have analyzed the Second Amendment regulations under the highly deferential Turner standard, it has been inconsistently applied and remains inapplicable. Turner deference stems from 2 Supreme Court cases that addressed certain rules imposed on cable television companies. These cases established a general rule that where policy disagreements exist in the form of conflicting legislative evidence, courts owe the legislature's findings deference, in part because the institution is far better equipped than a judiciary to amass and evaluate the vast amounts of data bearing on legislative questions. A few courts have imported this deference to analyze Second Amendment claims, but courts in our own circuit have been inconsistent in this application. In Pena, we applied Turner deference, but in Sylvester, Fayok, and Jackson, and Chauvin, we did not. The latter opinions get it right. Turner is an inappropriate standard for a simple reason. That line of cases addressed a very different set of laws and circumstances. There, cable television operators challenged the constitutionality of must-carry provisions of the Cable Television Consumer Protection and Competition Act of 1992. As the court explained in the Turner case, Turner 2, the deference provision outlined in Turner 1 applies mainly in cases involving congressional judgments concerning regulatory schemes of inherent complexity and assessments about the likely interaction of industries undergoing rapid economic and technological change. Though different in degree, the deference to Congress is in one respect akin to deference owed to administrative agencies because of their expertise. Not so here. While the issue of gun violence is important and emotionally charged, it does not involve highly technical or rapidly changing issues requiring such deference. The state cannot infringe on the people's Second Amendment right, and then ask the courts to defer to its alleged expertise once its laws are challenged. Put another way, intermediate scrutiny cannot mean Chevron-like deference. Indeed, this very argument advanced by the state was roundly rejected by the majority in Heller. Despite Justice Breyer's dissenting opinion explicitly advancing Turner deference, the majority in Heller did not once mention Turner and its progeny. To apply Turner today would amount to an abdication of our judicial independence, and we refuse to do so. And in any event, the Turner 1 court emphasized that deference does not foreclose our independent judgment of the facts bearing on an issue of constitutional law. Even if we were to apply intermediate scrutiny, the California 10-round magazine ban would still fail. While the interests expressed by the state no doubt qualify as important, the means chosen to advance those interests are not substantially related to their service. Section 32.310 fails intermediate scrutiny for many of the same reasons it fails strict scrutiny. Even with the greater latitude offered by this less demanding standard, the law's fit is excessive and sloppy. In his dissent in Heller, Justice Breyer would have upheld D.C.'s law under his interest-balancing test because the law was tailored to the urban crime problem that is local in scope and thus affects only a geographic area, both limited in size and entirely urban. Not so here. The California statute operates as a blanket ban on all types of LCMs everywhere in California and for almost every one. It applies to rural and urban areas, in places with low crime rates and high crime rates, in areas where law enforcement response times may be significant, and to those who may have high degrees of proficiency in their use for self-defense, and to vulnerable groups who are in the greatest need of self-defense. The law also prohibits possession outright, and it applies to all firearms, including handguns, that are the quintessential self-defense weapon. The law's failure to incorporate a grandfather clause is another red flag. We do not write on a blank slate on this matter. This court has already held that grandfather clauses are important in reducing burdens generated by a restriction. It follows that grandfather clauses are also important to assess fit. Without such a clause, law-abiding citizens who legally possessed LCMs before enactment are deprived of the right to use those arms for lawful ends. These law-abiding citizens could have owned LCMs for decades and perhaps even used them for self-defense in the past, but none of that matters under California law. They must turn them over or face a year in jail. Based on the record before us, there is no apparent justification or support for the lack of a grandfather exception. The state speculates that a complete prohibition is necessary to avoid legally owned LCMs from falling into the wrong hands, but the flaws of that argument are obvious. The state could virtually ban anything if the test is merely whether something causes social ills when someone other than its lawful owner misuses it. Adopting such a radical position would give the government carte blanche to restrict the people's liberties under the guise of protecting them. Yeah, think Isaac Asimov's 3 laws, right? While the harms that California attempts to address are no doubt real, California law does not address them in any material way. The data relied on by the state in defense of the section, as the trial court found, was remarkably thin. California primarily cites 2 unofficial surveys to support dispossessing law-abiding Californians of millions of magazines. But the district court pointed out that these surveys hardly show that Section 32.310 is effective, and in any event, they cannot save that provision. One of the surveys documents that in 14 of 17 mass shootings in California, assailants brought multiple weapons. This undercuts the state's claim, as noted by the district court, that LCMs shoulder much of the blame for casualties because the more weapons brought to a shooting incident, the greater the capacity for casualties. But more than that, the district court pointed out that only 3 of these incidents definitively involved LCMs, and for each, the assailant brought high-capacity magazines that were illegally smuggled into California. In other words, Section 32310 would have little effect on the outcomes in these tragic events. Many incidents do not appear to have involved LCMs, and for those that did, the LCMs appear to have been smuggled into the state. Put simply, California fails to show a reasonable fit between Penal Code Section 32310's sweeping restrictions and its asserted intentions. Were we to apply intermediate scrutiny, the law would still fail. Let us be clear. We are keenly aware of the perils of gun violence. The heartbreak and devastation caused by criminals wielding guns cannot be overstated, and we also understand the importance of allowing state governments the ability to fashion solutions to curb gun violence. We have thus held that California can, for example, impose waiting periods, require micro-stamping of guns, and forbid felons, the mentally ill, or misdemeanants convicted of domestic violence from owning firearms. We also want to make clear that our decision today does not address issues not before us. We do not opine on bans of so-called assault weapons, nor do we speculate about the legitimacy of bans on firearms holding far larger quantities of ammunition. Instead, we only address California's ban on LCMs as it appears before us. We understand the purpose in passing this law, but even the laudable goal of reducing gun violence must comply with the Constitution. California's near-categorical ban of LCMs infringes on the fundamental right to self-defense. It criminalizes the possession of half of all magazines in America today. It makes unlawful magazines that are commonly used in handguns by law-abiding citizens for self-defense, and it substantially burdens the core right of self-defense guaranteed to the people under the Second Amendment. It cannot stand. We affirm the district court's grant of summary judgment for plaintiff appellees. The dissenting opinion basically disagrees that intermediate scrutiny should apply and that intermediate scrutiny should keep the ban, should affirm the ban. And so that's basically the difference without going into the details. The one dissenting judge basically felt that the 10-round magazine ban was more reasonable and it fell under intermediate scrutiny, and under intermediate scrutiny, the ban was allowed. So obviously the 2 judges on the panel agreed that it was unconstitutional, and so the ban is overturned. And I think for now, that's the end of it. You can now possess magazines that are greater than 10 rounds in California under whatever other California laws are. I don't know if there's a waiting period or an import ban or a sales ban or whatever, but all those people who hadn't turned in or hadn't thrown out or hadn't destroyed their magazines, or maybe they altered their magazines, well, they can alter them back now, in my opinion. Again, I'm not an expert attorney. This is not legal advice. You're going to want to figure out for yourself whether there's some other California law that applies. But according to this, you can now possess magazines with greater than 10 rounds in California. So let me know what you think of that. Do you think that the court was right in its analysis? Do you think that the statistics they cited, that 10-round plus magazines or 11-round plus magazines are really not the thing that causes mass casualties, that is something else, it's bringing multiple weapons or smuggling high-capacity magazines or something? What do you think of the judge's thoughts on that? And you know, how do you feel about the opinion? If you are happy that the opinion makes the ban unconstitutional, are you going to enjoy the fact that you don't have to turn over your magazines, you don't have to buy new magazines or buy kits to change your magazines? I personally, you know, aside from my carry weapon, everything I use has a large capacity magazine in it. For competition, everything's going to be basically the largest capacity magazine allowed by 3-gun competition in my case. So I'm more or less happy to see this ruling. I wasn't really thinking that Pennsylvania was going to impose such a restriction, but I'm glad to see that the people of California, who are law-abiding gun owners, can now have their large capacity magazines. let me know what you think in the comments below. That is our show today. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, Floatplane, and Twitch. This is a community-supported channel, meaning we need your monthly financial support on patreon.com/ljfrench and sponsors.com/law. Thank you in the month of August to the following $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Benjamin Hitov, Steven, Blackleaf, Cute Grills in Your Area, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, Angie, Brandon Abel, Torpedon, and Creative Corruptions. And thank you to the $5 plus supporters who are scrolling on the screen in front of me and will be in the description below. The LED panel app was not working, so we did not get to use that today. I love you all. I will see you in the videos that drop. Have a great week. Bye.